kick it off and we'll roll.
Thank you for joining us today. We appreciate it. This is Lyle Hanna with the Hanna Research Group. We're delighted to have, 80 some of you, 83 at this point, back for COVID-19 HR Crisis Management. We're going to have a great program for you today, but I tell you what, progress has been slow over the past 3 weeks. We delayed a week or two just because there wasn't that much going on, too much politics and not enough decision making. But we're back with Jim Morris is going to be here with us. We're going to kick it off with Allison is going to share some stuff about vaccines, and Autumn's going to share some stuff about our improvement in the state of Kentucky, which is looking great. And we've got Brad and Troy and others here just for commentary and for fun. So welcome. Please put your questions and your comments in the chat box. And we're just delighted that you're here today to join us. Allison, what's going on with vaccines?
Yeah, all right. Good morning, everybody. So what we've got in the PowerPoint today is just a sample communication for employees that you could use to kind of communicate the company's stance on vaccinations and give people some resources. I'm not going to read this to you. Like I said, it will be available on the PowerPoint that's uploaded to the website after the presentation. But basically, the important things to note are, like, for example, a lot of our clients have decided not to require the vaccine at this point, but to strongly encourage their employees to get it. So what they're doing is sending out communications saying, you know, we strongly encourage you to get it. We're working with CDC and local health officials. They're sending out resources to allow employees to do their own research, and they're also sending out resources to allow employees to sign up for vaccination. So again, kind of doing everything possible to encourage it, not necessarily requiring it in a lot of cases. Now, that's not to say you shouldn't. That's just to say that this memo really addresses those employers who are allowing it to be voluntary. So just keep in mind the verbiage you're using: strongly encourage versus require versus you know, we ask that you consider getting the vaccine. You know, make sure it matches your kind of company culture and the way that you communicate. But on the next slide, we've got a couple of different locations, and this list continues to increase. I think when I first drafted this for presenting to you all, there were only 2 options, and now we've got 5 options for vaccines, so that's great. And that regional vaccination location option has a ton of different locations, so there's not just 5 options total. But basically just continuing to give employees more information as it's available, link to the CDC vaccine information, link to Kentucky's COVID site, and then UK, Kroger, Walgreens, Walmart, and all the regional vaccine links. So again, you're welcome to use the sample template. You're welcome to adapt it for use in your organization. Just a helpful tool to keep people informed.
Thank you, Allison. And I'm the proud winner of a second vaccine this last weekend at Alltech Arena, and pleased to be qualified to get that and have it behind me. And I had no reaction. I've got a little, feels like a bruise on my arm, and that's it. And only if I push on it, I can even tell it's there. So, man, they were good at giving those shots. I just think maybe I was lucky, but no reaction. That's great. And I want to tell you guys that, you know, a lot of these places, since they have those cold vaccines, they have some left over at the end of a lot of days. So I've got quite a few friends that have called in and said, you know, if you got any left over, I'd like to be on your list. And some people have gotten vaccines that way. So at Walmart, not Walmart, Walgreens, I know that quite a few people have picked up vaccines that way. So I encourage you to get them. All right. Anything else, Allison? Any questions in regards to this?
Jim had just posted there's also an option at Keeneland to sign up for vaccines. So check out the chat for that link as well.
Now, do you have to place a bet to be able to do that, or can you just go out there? I guess you got to sign up. Okay, sorry.
You can take a gamble on whether you can get in or not.
Yeah.
Sorry, had to go there.
We would gratefully accept the bet. The wagers are always acceptable.
There you go. John Green, straight from the horse's mouth at Cleveland. Thank you, John.
At least one end of the horse, I'm not sure which.
All right. Thank you, Allison. And I think Autumn's going to share some news too.
Yeah, so some good news. We spent a lot of time looking at this red map over the last couple months, several months. So this is as of February 6th. And then the next slide shows February 27th. So you see a lot more improvement here. If you want to go ahead and flip to the next. Only 30 counties left in the red, so that's great news. A lot of those counties are in rural areas. And then 18 are now in the yellow, so that's really exciting news. Two of our largest, Jefferson and Fayette, are now orange, so that's exciting as well. Whether this be the vaccine, I'm sure is playing a role, but also other factors too. It's exciting news, and we might be there might be some light at the end of the tunnel here.
All right, now for the hardcore. Jim.
All right, so I wanted to point out one thing on this map too, that Autumn talked about, just so you know about population centers. You've got Boone, Kent, and Campbell up in the north. You've got Jefferson, Oldham in the Louisville area. You've got Fayette, Bourbon, Clark, Madison, Woodford. Now, Jessamine is really close. Actually, if you look at it, I think Jessamine, no, it's a 31. Jessamine and Scott are close, but if you look around the major metropolitan, then you go down to Warren County, and even Warren County is in the yellow Simpson, so on. So you're getting a lot of areas that are more urban areas that are not in your red area. So one more time, and I could have gone back and gotten a map that's just all red, but we literally went with February 6th. That's a 3-week time period. Look at the change in the 3-week time period. So it's really good news. So I'm me. If you don't know me by now, you haven't been on here, so that's enough. So I'm going to roll right into this. I started out with the vaccines because I wanted to address the issue that we had the memo about the voluntary. Let me go back to that for just a second. It's a great idea, and I'm really happy you guys are going to get this from Hannah, but I'm going to give you some caveats now, the bad news. So this is the suggested language, and it's really good, except for what's getting ready to happen now, which is now the businesses are the government is starting to address things, and it's becoming a little bit more convoluted, a little bit more disappointing, and all the things I was warning you about at the beginning of January are coming true. Yay. So first, with regard to your vaccines, let me start with GINA and ERISA, because I had talked to you about ERISA, ADA, EEOC, talking about whether you should or shouldn't, whether you should outsource. Well, I've been doing some research and getting some more information, and so here's the bad news. So you've talked about the policies, we've talked about the mandates, now let's get down into the nitty-gritty. So on ERISA, if you don't know what ERISA is, and we've not really talked about it much on this call, or on any of the calls, ERISA basically is, well, it's the Employee Retirement Income Security Act. Basically what it is it makes employers do certain things for their employees. If you don't do them correctly, you get into trouble under federal law. So, under ERISA, right here, if an employer provides or pays for employees' medical care, the employer has likely created a group health plan. Fair enough, no big deal yet. A vaccination is medical care under ERISA, so now you start to get a little bit more concerned about whether or not you can do a vaccine. And I'm not talking about mandatory. I'm talking about encouraging. This is a big issue. So now you are encouraging people to get the vaccine. Is that a medical plan? Is that medical care? Could potentially be. You should wrap up any incentive program. So if you're trying to do this, the suggestion is, oh, hey, let's have a pizza party for everybody that gets the vaccine. Let's give you $25 gift cards. Yay. That was all considered okay under the previous administration until January 21st, when the wellness plan got voided. Let me repeat that. The wellness plan language that the previous administration wanted to have available got voided. What that means is you can no longer incentivize right now because there's no guidance out there. We're going to get to that here in just a second under the ADA. So GINA, we've talked about some. I just want to talk about this a little bit. It prohibits you from requesting genetic information from employees. We chatted about it. You guys have heard it. I've told you be careful. It can apply unexpectedly to a wellness program. So employers that administer or have a third party administering, you need to make darn sure that any of your screening questions asked don't elicit it. And then the other one is, if you are doing an incentive plan and you say we're going to give you, and I'm not comfortable yet with $25 because it's free. You'll see why here in a minute. But let's say that you're going to give a $25 gift card to any employee that gets the vaccine. Okay, what if I don't get it, but I have an allergy? You have to give me the $25 gift card. What if you ask me though, well, wait a minute, I can't give this to you, you didn't get the vaccine. Why didn't you get it? The why is a GINA protected question, so you can't get into that. So now you're seeing a problem with incentives and disincentives, and possibly ostracizing or creating problems for people who did not get the vaccine for potentially a legitimate reason. So let's go the next step to the next issue, which is ADA. So now we've got, we talked about right here, ERISA and GINA. Now see how this plays with ADA. So going into the ADA, Health Insurance Portability Accountability Act and health contingent issues. If you use incentivizing, you have to comply with HIPAA wellness programs. If you're not familiar with that, chances are your policy may not be compliant. Basically and this is the big kicker too, is the DOL and Health and Human Services came out along with the U.S. Treasury and a whole bunch of others and said, okay, look, getting a diagnosis, wellness, you go out, have people tested, you can do that before they come to work to make sure, because this is a pandemic, CDC, so on and so forth. Key word was diagnosis. They never have addressed vaccination. So is vaccination non-HIPAA? The answer right now is no. It is HIPAA, so if you're doing it under incentive program, you have to comply with the wellness program rules. The wellness program rules, what are they? Basically, there are two consequences to a wellness program being used. Okay, first, you must comply with limits on incentives. Let me say that again. You must comply with limits on incentives. Incentives used to be allowed until January 21st, and incentives used to be allowed to be incentivized. $100, $50, free gym membership, whatever you wanted. That all got voided. So right before the administration left, they spelled out what they thought would be an appropriate health incentive. That got thrown out with everything else. Right now, there is no guidance as to what is an appropriate incentive under HIPAA's wellness program rule. It does typically equal the cost of the plan. Well, the cost here is free. So with the throwing out of the wellness program under EEOC guidance, and with the cost of the program being free, you have a little bit of an issue. Then, employees who cannot receive, and this is the second part of the wellness program, employees who cannot participate in your wellness program for whatever reasons, and they call them health status factors, they must be provided a reasonable alternative method for earning the incentive. Well, how are you going to do that with a vaccine that you either do get or you do not get? And how are you going to handle that if you don't incentivize across the board. So the voluntary with incentives is going to be very problematic for a little while here because there's no guidance, and we've now been told we're going to issue it in the next 60 days, then we're going to have 60 days public comment, and then hopefully after that we'll have an answer for you. That's June, July. That's way too far down the road. The last one is with regard to these health contingent issues that are identified right here in the HIPAA. Any vaccination incentive program must include the health contingent issues in the incentive program. It could be an allergy. It could be another condition making a vaccine inadvisable. It raises questions, and this goes back to my February the 7th, the last webinar we had. We talked about the religious discrimination, the true religious objectors to vaccines. You can't ask questions. So now this is not supposed to be non-health related, but with the new guidance on religion, question comes up whether you can disincentivize because of someone's religious beliefs, or incentivize and disallow because of religious exception to the vaccines based upon the EEOC's new guidance issued on January 21st. So basically what I'm telling you is this is really a mess, and I don't know how to tell you how to handle it because it's kind of a problem. You'll see on the next screen a real question and answer you're going to have to ask yourself. But any kind of vaccination program with an incentive could well be a HIPAA health plan that then has health contingent wellness concerns because people may not be able to receive those. These are things that if you are not getting guidance on, you need to make sure you are, and you're going to see here in a couple of minutes why that has become suddenly shockingly concerning. Yes, I'm burying the lead. If you're not aware of the NLRB rules, you're about to be, if you're in human resources, you're about to be shocked because our whole employee handbook policies have changed. All right, so then I told you this was coming. These are the concerns related to vaccines caused. So where does all this leave us? We have a great voluntary memo that you can send out that Hannah's put together. You've heard my concerns. So here are some legitimate questions. Just because you can legally require or incentivize, should you? Here are the things, and this is not me, this is a nationwide, I read several different things. I wanted to just raise this to you. Be thinking about this because as an employer, HR, workers' comp, general liability, exposure to risk and harm, these things are real. And this is, I'm not sure what the answer is. So here's some thoughts, food for thought on should you really be thinking about even incentivizing. Number one, they're new. They've been fast-tracked, the vaccines. We have a third one today. I didn't put it in the slide. It got approved yesterday. It was FDA emergency approved on Saturday. Then it got sent out yesterday. I do have a comment on those. I'm going to give you my non-medical comment on the three. I've heard some people say, well, but the Johnson & Johnson is only 66% effective. I had dinner with two doctors on Friday, and I talked to them about the different vaccine. One of those doctors got deathly ill on one of the two other vaccines, second dose. The other one, the wife, laughed at the husband and said he wasn't deathly ill. I think it was the cold, and she took the other vaccine, so they had a back and forth over which vaccine was better or worse and so on. But the comment made from the one of the two doctors about the Johnson & Johnson was, yeah, you know, everybody's hung up on the percent effective. It's 100% effective at stopping, so far, at stopping major illness and death. It was 66% effective at completely stopping any COVID-19. They said you can't look at the 66 or 71%, different numbers on depending on it, based upon whether you can get it, because we're not concerned about people getting it, we're concerned about people dying from it. So they went down through and addressed some of that. And I talked to them, I'm gonna send my expense in to Lyle because I did it for business purposes, so you have to pay for my dinner. He doesn't pay for anything anyway. So this is the question and answer on these. So the first one is, because they're new and they were fast tracked, it doesn't mean they aren't good, but it does mean that they haven't had a whole lot of tests on effectiveness and, bigger issue, long-term side effects. This is not a political statement. This is not about how I feel about vaccines. This is about an employer being liable because you either strongly encouraged, required, tacitly required, threatened, coerced, or incentivized. Because if we find out that 5 years from now, everybody who has, I'm making this up, everybody who has the vaccine ends up having some kind of side effect, because the Moderna or the Johnson & Johnson. If you required people or incentivized it and they have documentation of it, the question is, should you wait or not? In being the employer suggesting that people get these. Again, I'm not talking about you individually, I'm saying an employer being liable from a legal perspective. The second one is, if the employer requires someone to be vaccinated, or even strongly encourages, and something bad happens, we have had some adverse reactions, we've had some people who have had all kinds of things happen. What happens? There is no law yet addressing employer liability. Is it workers' comp? If somebody dies, is it a wrongful death? Do you have liability? If you required it, chances are you do. If you incentivize it, chances are you probably do. So that's another question to make sure you're familiar with and that you at least talk about and make a conscious decision about. Then the GINA HIPAA incentives could be interpreted to be a mandate. That goes back to what we were just talking about. Because incentive language could be interpreted to be a requirement of the employer, because it's no longer just a, here's a pizza party, it's now a, you're stigmatizing or you're causing concern to those that can't be, so they could create a problem. The fourth one that's out there that's being talked about is, could this be an employee relations nightmare? Because employees, some very good, well-meaning, good working employees are concerned about the vaccine for any number of reasons. Some of these are not your anti-vaccination, some of these are not the conspiracy theory. Some of these are people who truly have concerns about a vaccine that hasn't been fully vetted. What are you going to do? Because golden rule, as we've talked about for weeks and weeks and months, treat every single employee the same. So what if Sally comes to you and Sally says, if she's your best performing employee and she says, I just can't do it. I'm afraid to do it. Are you going to fire her? Are you going to remove her? What are you going to do? We talked about the ability to fire and not. But just keep in mind the concern you have about strong-arming, enforcing, or coercing. The last one is a CDC recommendation does not equate to immunity, and this is really important in Kentucky right now because, you know, we've got a governor who's fighting the legislature. I don't know whether you've heard about that, but one of his arguments is CDC is only giving guidance, and this is the governor. And it's a little interesting because early on, the governor said we rely on the CDC, so all of my recommendations are based upon CDC. But then when he got caught in this legal argument on it, he's now taking the position that the CDC literally does not give rules, they only give suggestions. So this fifth one is really important because just because the CDC is recommending it does not equate to immunity. So the question for an employer is, what happens to the employer for disciplinary actions, for adverse reaction to a vaccine, for someone who legitimately can't take it and feels like you ostracized them? What's going to happen with the court system? You all know the court system. You know the fact that there are bad attorneys out there. And they do a lot of lawsuits. I'm sorry, not bad attorneys. There are people who like to sue employers for not following guidelines. And some of those just like to file lawsuit after lawsuit. So just because the EEOC says you should do something does not mean you couldn't end up in a lawsuit with a court or a plaintiff's attorney that gets a judgment against you for doing it. So let me move on to the next issue, which is what I was just talking about. So where are we with the legal wrangling? We have over 120 people on here right now. Some of you may have left to go watch the incredibly amazing legal argument of the governor versus everybody else in the world, because that is currently being argued in Franklin County right there at 11 o'clock. There was a Zoom invite, but I didn't put it in the chat because I knew all of you would leave to go watch the riveting testimony and legal argument of government paid attorneys fighting other government paid attorneys and all your tax dollars with the huge sucking sound going down. Because that's what's happening is the Senate has its attorney being paid by us, the House has its attorney being paid by us, the Attorney General has 10 attorneys being paid by us, the governor has 20 attorneys being paid by us, everybody and their brother has an attorney and we're paying for them all. So they're all arguing right now in Franklin County over what's going to happen. In a nutshell, what happened was there was a hearing back on the 23rd. The judge extended the injunction for a 10-day period through the 3rd of March and said he would issue an order in the next 10 days. Today was the 10th day after he suggested he would have it out. So I might be wrong. It might have been the 21st with the hearing or 22nd. I anticipated doing one by today. I believe he's going to do one after this hearing. There was a list of 18 pages of executive orders that would be impacted by an order of the court. Having a governor issue 18 pages of executive orders, what an executive order means is something that's typically not in his authority or control. It's where he has taken over the legislative side of something because the legislature didn't do it. So he's done that. They asked, the listing was ridiculous. I could put it on the screen, put it in the chat box so you can read it, but I don't want to put anybody to sleep until I'm done, so I'll put it up at the end. So that's the update on the legal issues. I expect you'll hear a whole lot on ABC, NBC, CBS local, Fox local this afternoon, because right now they're having the hearing. This afternoon he'll probably extend it. I have my own personal belief, which is he will probably rule that the injunction stays in place. Here's your little caveat, Jim's prediction on legal issues of the day. The judge is not a political appointment. They do not put what party they're affiliated with, but I know this particular judge. I know his particular political party. I will tell you what's going to happen. The legislature is in session until their very last spread of 30 days. They spread out by doing this. We talked about a couple months ago. March 29th. So here's what's going to happen. Around about March the 21st, the judge will issue an order. This first one's going to be just partially regarding the one bill, House Bill 1, Section 1, about whether the fact that people could open under any rule, CDC, state, federal, they could ignore an executive order. That's what he has entered the injunction on right now. The reason why he'll wait until closer to the end of March, because then there's not enough time in the session time period for them to issue a new ruling or a new bill that then could be vetoed, that then could become law. So he's hoping to end run the legislature. He's got a small problem, the judge does, because the legislature actually has, today is voting on, you'll see here in a minute, being able to extend their own session by themselves without a governor mandate upon 3/5 vote of the House and Senate. So all they have to do is they can keep extending it 10 days, not past the end of the year. and that's probably what they're going to end up doing. But that's what I think is going on, is you've got a little bit of slow play from a judge to wait to see if we can get beyond a new bill, and you've got a ruling today that's going to probably extend one part of it, wait on the rest. He's probably going to enter an injunction across the board at the end of the month. Then you'll be up on appeal. Then we're going to be addressing things for the next 6 months while we wait for the Court of Appeals to rule on the injunction. Just my prediction. All right. Here's the update on the legislation. So these are the ones that impact businesses. Yes, there's about 150. Yes, I read every one to figure out which ones actually impact you as a business. And yes, some of these have nothing to do with COVID. But we're here to give you as a business information. So House Bill 4, this is the one that I told you is probably going to be adopted today. It's in the Senate. It's up for a final vote. It allows the General Assembly to basically cancel the adjournment date, extend it 10-day increments as long as it needs to. That's going to be voted on today. It'll be vetoed by the governor or unsigned, one or the other, and then it will become law either because he didn't sign it or because they overrode it. The next one, I talked to you before about House Bill 10. It is a limitation on the liability under COVID-19 as long as you acted in good faith. It's supposed to be retroactive. It also protects public school officials. That will become law, in my opinion. These are not, let me be clear, these are not law yet. They will become law because of the supermajority. Most of these were some of these were unanimous. Most of these were 1 or 2 dissenting votes in the Senate, 8 to 10 in the House. They're pretty close to being 100%. The third one, I didn't also for my Buffalo Trace Distillery people on the phone or on the call, I didn't include these, but they were near and dear to my heart. There's a whole lot of microbrewery distillery policies that are going to be in place where you can now start shipping and acting as your own distributor and doing things finally, which should have been done a long time ago without restriction, given everybody else in the world's doing it. We were the last to jump on board. So now you can have, hopefully, knock on wood, bourbon shipped straight to your house, straight from the distillery. They can also send you samples. Woohoo! So here's the next one, is that grocery items can be sold by restaurants. That's a new one. Also, another one I didn't put in here. I put this one in here because there are some on here that are restaurant. So it's precluding any limitation on restaurants selling bread, milk, other things in non-prepared meal type situations. The other side of that, I didn't put it in here, but they're also allowing to-go alcoholic. I know that there is some of that going on with COVID, but this one did not appear to be a COVID-related limitation. They're going to allow that widespread. I can hear everybody cheering right now. That's what I'm here for. The next one, House Bill 210 is huge for you. If you're not familiar with it, wait for it. Don't change your policies yet on handbooks until you get to the end of this webinar, because we have huge changes to your webinar. But under House Bill 210, anyone in your employment who adopts a child will be treated the same as birth parents for purposes of leave. So you have to make sure that your policies and procedures allow for for adoptive parents to have the same leave. That's still in the works, but it is something that will be adopted, I believe. It was a unanimous, that was 100%, 98 people to 0 with no abstentions, no dissent. So that's going to be law. That changes your handbooks, so keep that in mind. The next one is PPP Common Sense. Kentucky's tax code, for those who don't realize it, is different from federal, so you may get out from paying taxes at federal, but you still have to pay taxes in the state. Well, House Bill 278 took care of that and said that we will treat all monies received from PPP the same as federal. So now your taxes in state, you won't get hit with a tax for getting a free donation from the federal government. House Bill 413, unemployment insurance. It establishes a state-sponsored pool during states of emergency because we didn't have one before. It applies retroactively. It will not impact if you have a state of emergency unemployment. Doesn't impact your reserve account. And it also had some additional language in there about how you're going to calculate your SUTA rate and so on based upon the emergency of the last year. Not going to go into a whole lot of detail. If that's important to you, just keep in mind House Bill 413. Senate Bill 7. This one addresses unemployment. It has established a fraud prevention investigation unit and efforts and allows them to go out and start prosecuting people for stealing. So you may have employees that are part of that. It does have a specific waiver for anyone who got accidental overpayment because of how stupidly complex, ignorant, and ridiculous the whole system was, the lack of any responsiveness from anybody at the Unemployment Insurance Commission, and the fact that, by the way, since March the 14th of last year, I'm still waiting on my phone call return. So this basically is a new way for them to start going after people, but it allows them discretion to not go after people who got caught up in all of the confusion. Senate Bill 8, this is critical with us talking about immunization. There are going to be exceptions to mandatory immunization. It prohibits mandatory vaccination requirements. It allows people to be a legitimate objector or to write as long as they have a firmly held belief. You can't take action against them, and the government cannot force them to have a vaccine. Keep that one in mind. It may not pass, but it's out there, and it should, based upon the number of House and Senate that are looking like they're voting for it. Last one is not COVID related, but it is COVID related. It extended all deadlines for the Human Rights Commission with regard to various actions, when they have to file a lawsuit, when they have to investigate, how long people have to report it, and so on. So anything that you have with regard to human rights investigation in the state level, HRC, if it's filed in conjunction with the EEOC, we don't know yet how much that's going to be impacted, but it definitely impacts the claims because it's giving an extension because of the pandemic. So those are the ones that are up right now. Okay, so now let's get into the federal. This is the fun and games I was telling you about. I hope you stayed on because this gets into some this is what I was warning you about when I said there's some new things that are going to come down the pipeline that are going to drastically change employers' landscapes. This is the very first one. If you remember, I told you on the February 7th call and the January 28th call, or somewhere around there, there were a whole bunch of executive orders that were entered on January 21st. Those executive orders basically said, all stop on anything that was related to the previous administration, cancel anything that was in the works, stop your wage and hour, stop the Department of Labor, stop the NLRB, all stop. We're rewriting all of our policies and procedures, and we want to be pro-union. We want to be anti-border. We want to be, and this is literally what's in these, basically pro-immigrant, anti-minimum wage, things like that. Well, this is the first shoe to drop of many that are getting ready to hit, and you've got to be up to date on this. So the first one was a veto of a previous memo that was issued by General Counsel Robb, R-O-B-B. He issued an order that had said, here on out, employers have a right to establish policies with regard to certain things in the workplace, and they are not anti-union. On the, I think it was, I meant to write the date down, I think it was February 16th, February 15th, the NLRB new interim general counsel voided in its totality the previous memos, 12 of them. This one was the key one in my opinion. Handbook rules, previous memos said These things did not interfere with an employee's rights under the National Labor Relations Act, and therefore you are allowed to utilize these in a handbook. Some of these are going to sound like common sense, but now that you can't do them, you're probably going to be sitting there looking at it going, you've got to be kidding me. These are now potentially illegal under anti-union provisions. No, I'm not kidding. Number one, mandatory civility rules. You can no longer mandate that people be civil at work. That is an improper anti-union activity. Number two, you may not be able to preclude photographs and recording devices at your place of work. That could be considered attempting to limit union activity. Number three, you cannot ban insubordination and non-cooperation. Now, I'm not joking. These things are literally the memo that was thrown out. The memo said employers could have civility rules, employers could preclude the taking of photographs and recording devices and recording things without permission, that employers could discipline for insubordination and non-cooperation during work hours affecting the overall activities of the employer. You can't do that anymore. You can no longer ban disruptive behavior, including fighting, fisticuffs, horseplay. I mean, it went down through a whole list of things that you could do that has now been vetoed. Number five, you cannot, I love this one because I do a lot of trademark, I do a lot of proprietary, I do contracts, maintaining confidentiality. You cannot possibly ban disclosure of confidential proprietary information and customer information. You may not be able to ban defamation or misrepresentation regarding your business. You may not be able to ban the unauthorized use of your company's logo and intellectual property. Again, let me repeat that. You may not be able to ban the unauthorized use of your company's logo or intellectual property. The bizarre thing is when this was issued in 2018, this particular memo that said we're clarifying all of these things don't violate, and yes, there were lawsuits that said that these violated union activity, and they came out and said, no, they don't. These things are now specifically allowed in a handbook. Now they're not, until they come in and tell us otherwise. Number eight, there was a requirement, or there was previously an indication that you could require people not to speak on your behalf as the employer without prior permission of the employer. For example, if somebody picks up the phone and calls and says, I'm calling from the Courier-Journal and we'd like a comment from the employer, and the janitor's the one that answered the phone and starts speaking, you can't stop them from doing it, apparently. The last one is there was an understanding that you could ban disloyalty, nepotism, and self-enrichment. Now that's been stricken as well. There's no longer the ability right now, or potentially the ability. I'm not saying that this is a rule. They lifted the rule that said your handbooks could have these things in them. So right now, the stance from the federal government is the memorandum that allowed you to have a handbook that said you have to be loyal, you can't use nepotism, and you can't get rich for your own self-purposes based upon your employment is not authorized, because that memo has been voided by action of the NLRB. So unionized activity is alive and well. The NLRB chair is the previous union national rep for all unions, is now the chair of the National Labor Relations Board, or I'm sorry, it's up on being approved by the Senate. So if you don't think that there's a change coming to union activity, anti-union activity, and the NLRB's enforcement of unionized activities, and you run anything that could be potentially unionized, from the national, the electricians and plumbers to the janitorial service, the teachers, anything, unions are about to become the strongest bargaining chip around. So be very, very mindful, very careful, and start investigating your handbooks, because everything you built your handbook on in the last 4 years is void. All right. The other two things that the NLRB did and the Department of Labor, number one, the acting general counsel indicated the rights of non-union employees to object to the use of union dues for political purposes is void. Again, non-union employees under previous administration had the ability to say, I do not agree to any dues being used by the union that's representing me, even though I'm non-union, to inquire of and determine political donations, political purposes, and so on. That's been voided. Now, union activities with political purposes will not be transparent. This was an effort to force them to identify what they're doing with the money. Now they're not allowed to. So the other one is, so this one is with regard to the non-members about rights to not be charged for fees related to political and other activities. That's gone. The second one required detailed information in response to a fee objection case. They no longer have to do that either. That's been voided. Department of Labor has frozen implementation of two things that we spoke about back in January. One related to independent contractors and the other one related to tip pooling. Both of those are frozen for a 60-day time period. Neither one's going to make it to the light of day. They're going to issue promulgate new rules, but those regulations were on the books. They've been pulled back. And this is just the beginning because EEOC has to issue new guidelines by the 15th. OSHA has to issue new mandatory mask guidelines that all of you have to comply with by the 15th. The NLRB has another one left that they have to do by the 15th or the 30th. Whole lot of changes coming in the next 2 weeks. As Lyle indicated, we're kind of in between the storm right now. But this NLRB one, especially this handbook one, scares the heck out of me because we don't know yet. This isn't EEOC, this is NLRB, but we don't know yet what that impact is going to be across the board and how you're going to be able to have a handbook that allows civility, which, by the way, the EEOC requires. But now the NLRB is saying it could be an anti-union. So now you've got an EEOC that says you have to have civility requirement and training, and you need to have rules to make sure people are civil at work. Now you have an NLRB that says, but wait, you can't have civility, you can't preclude insubordination and disruptive behavior because that might tamp down union activity. So it's going to be interesting to see how those two can comport with one another. All right, cancel culture. Last one I want to talk about. Yes, I'm going to be really, really careful here, but I've gotten this question asked multiple times, and this is the brand new normal. Little history, my son I think is on here, so he would probably laugh out loud when he finally hears this. I told my kids when they were about 8 years old and they started to do anything on the internet. Now, my son is now getting ready to be 27 years old this year. Is that right? Yeah, I hope that's right. So he's going to be 27 years old. So you're looking at 19 years ago. I stopped being on anything. I didn't join MySpace. I didn't join Facebook. I wanted to be a ghost. I never ever wanted to be on any social media for this reason. I knew it is a stamp in time that never goes away. You can delete your tweets, but somebody has them on their computer. You can delete your Instagram, you can do whatever you want, you can make it a temporary, but there's a way for people to record those temporary posts. I warned my children starting as young as they were able to have an email account. When you turn 18 years old and you try to get a job, this will be used against you. Somewhere down the road, you're going to wish you hadn't posted that about Tiger Woods, Calipari. I don't care. Somewhere, sometime, somebody's going to be offended by something. And we are now in that time where anything you posted in the 1990s or early 2000s is probably offensive to someone. And some of those things were not offensive until recently. For example, Synarchastical story number 1. I don't know whether you've heard or not, but the Loudoun County, Virginia School Board has banned Dr. Seuss because Dr. Seuss is racist. They've gone back and they have determined that there are racial undertones and stereotypical undertones. Disney is now putting up an apology before any Muppet show because they bought the rights to it and they now have it on Disney+. If you go to watch anything Muppets, there is an apology at the very beginning that says that the stereotypical and racial undertones are entirely inappropriate. They weren't appropriate at the time and they're not appropriate now. I watched Fat Albert growing up. I can't imagine what would be said about Fat Albert now, both because of Bill Cosby being the creator and all of the issues in the show itself. Stuttering, obesity, I mean, I cannot imagine the issues, all the trauma that it might leave somebody if they watched it. I'm not being sarcastic because that's legitimately, there were issues in that show at the time that I knew weren't right at the time. So here's my cancel culture discussion because I'm getting asked this repeatedly now. Whether it was people going to the Capitol to protest that got fired even though they didn't storm the Capitol building, but they just happened to tweet that they were in the Washington Monument or somewhere for a protest. Here's the issue, guys. All the tweets, posts, Facebook, MySpace, yep, that used to exist. If you're newer, go back and look. It's still there. I actually logged in to see. I don't have an account. I just pulled it up to see if they had actually canceled it, and they hadn't. Question is, what can you do in response to public outcry, embarrassment, or you know what, you just don't really like what they said? And the answer is yes, you probably can fire an employee or be fired as an employee for tweeting, posting anything inappropriately, or even something that, let me pick something that's terribly divisive in this state. Go Big Blue versus Card Nation. You literally could fire somebody for putting in the wrong color or believing in something. Doesn't matter because almost everybody's at will, which means I can fire you for any reason as long as it's not a discriminatory reason. So, even if the post occurred years or decades before you became employed, your employer can do that. They can fire you as soon as it comes to the surface. So that's why I did that. That's why I told my kids, don't ever drunk post. Don't ever go out and do something stupid. Don't send a naked picture, almost naked picture, or think it's a naked picture. Don't forward naked pictures. Don't do anything with anybody else's pictures because it will catch up to you in so many different ways. It's scary. In today's culture, with everything going on, and this kind of came up because I don't know whether you knew Ted Cruz got caught because his wife literally said, hey, anybody else want to go with us? You know, by the way, anybody care to watch my dog while I'm gone? So that tweet or that text got forwarded, got published, embarrassment happened. He was on the next flight back home and whatever. Highly recommend. Employers, keep it to business if you're going to do it. Have no political comment, have no stereotypical comment, have no publications of anything that could come back. The problem is you don't know what's going to be controversial 5 or 10 years from now. You don't know what's going to be a hot topic. And I'll give you an example. President Obama, when he was a local community leader, believed very strongly in a man and woman marriage. He believed very strongly in the rules protecting a man and woman, laws protecting a man and woman marriage. When he became president, that was used against him repeatedly because it was all over the place. He never thought that would come back to haunt him because he never thought there would be a change. You have to be thinking as an employer and as a business about the potential of your business being completely canceled 5 years from now from posting something that at the time you posted it, Dr. Seuss, was 100% okay, but now is not okay. So we're highly recommending that employers and employees delete things from your distant past, get rid of your drunk texts, your posts that make you look silly or stupid, anything, definitely anything that could be racially homophobic, you know, the texts and tweets, the locker room comments, the texts about women, the tweets about women, or vice versa. Delete those. You don't want them in your history, even if they're 15 or 20 years old. Now, keep your contacts genuine. Don't send them to other people. And if anybody breaks your circle of trust, like the cruises, there's a text out there now, screenshot, showing that she texted somebody, I guarantee they're not going to be on the Christmas list next year. But make sure you know before it becomes a potential cancellation of your business. And this is serious because you literally could lose your entire business. We've seen it happening where businesses are either physically destroyed or they're destroyed online by taking a stance or a position, even if it was 15 or 20 years ago. So be mindful of that. Scrutinize your posts, scrutinize your tweets, understand where you're putting that, and then where does this come full circle? I tell you to do all this, and then I remind you, except for one thing, because you can't preclude people from using your logo, intellectual property, speaking on behalf of the organization, but you darn well should try to do the best that you can to keep it to a minimum. So that's your cancel culture for the day. I throw that out there because I am getting more and more questions about, can we fire this person, or can I be fired for something I did when I was 18 years old and now I'm 30 years old and I never thought that would come back to bite me? The answer is yes. And it's why to be blunt about what I told my kids, they should treat their, and I know they didn't, so I know you're listening, but I told them they should tweet all of their personas online as if one day they would be running for president or sitting in front of a Senate panel answering questions about what they said when they were 15 to 18 years old. If you think about Justice Kavanaugh, I don't know how the man had a physical copy of his journal or his calendar from when he was 12 to 15 years old, which was 35 to 40 years ago, but his mom kept one. Now you don't need that because everybody can go in and see what you said when you were 12 to 15 years old on your own Facebook, Twitter account, Instagram, or anything else that's housed out there on one of these, because it stores it forever and ever. So that's my cancel culture. Be aware of that. Be mindful of that. If you're taking action against someone based upon their previous posts, document the heck out of it, because chances are they're going to challenge you on it. But you stand pretty firm on that because you have the ability with employed at will to fire anybody for any reason or no reason at all. So we're up to questions and answers, but you know how this rolls. I skip to the next one and we put this on the screen so we can turn it off at the end and talk to people. So there we go. And start asking me questions and I'll start to read through the, I'm going to answer one right now because I happen to be on it. The NLRB change is effective as soon as they voided the memorandum upon which everyone's handbooks were being based. The problem is, and that was Rebecca asked a question, is the NLRB change effective immediately? I missed the first part of what he discussed. Should we update policies or wait? Last one's a loaded question. You need to update your policies because your policies were based upon a civility rule that existed in a memorandum that was issued by General Counsel Rob in 2018, which was great news for human resources. Now that's been voided. The problem is, should you do it now or wait? There is no guidance out there now. All they did was say all of that's out, so all of this could be union activity. The problem is, and if you were in at the end, you did hear this part, the problem is we have EEOC guidelines that literally say, I've got frustration with some of theirs, but literally say you have to have civility rules and civility training in your workplace. It's your obligation to make sure that people don't get into violence in the workplace, don't get into non-civil behavior, and yet you're now being told by the NLRB, but that could be considered anti-union because you could be stifling anger from the union that we want them to be able to do. My frustration with the EEOC is when they, and I think I mentioned this back in April or May, when they actually literally started saying that you cannot refuse to hire somebody because of a criminal background, and they started criminal discrimination. And I had a big company. If you've had that, knock on my door, because I had a big company and I told them when they got hit with one, I said, I tell you what, let them file a lawsuit and let me stand in front of the jury and I'll do it for free, because I'd love to be the first one to prosecute an anti-criminal discrimination lawsuit. I find it offensive that we're supposed to be protecting against age, gender, disability, race, national origin, sexual orientation, and somehow in all of that, it's become criminal discrimination. But it's out there. So my guidance to you is don't issue new policies without making darn sure that you're adhering to that, especially if you're in a unionization area. You know, there's a lot of distilleries on this call. There's a lot of, well, like the horse park, the horse Keeneland. There's a lot of potential areas that could be unionized. You need to make sure your handbooks are very carefully worded so that you don't, no, there was a comment made, the new voided rules only apply to union shops, not the handbook rules. That's the other one that it only applied to, which was the people not paying their union dues that wanted to inquire about fees and so on. Overpayment of, and let's go with you asking me questions so it's not just me reading them all.
Yeah, and sorry, I had to step away the last about 3 minutes for a call, so if I ask you and you've already answered, just skip it. But we had a question about, is the NLRB change effective immediately? Should we go ahead and update our policies, or should we wait on any other guidance?
Skip it. I already answered that one.
Okay, perfect. And then, is the NLRB the do-all and be-all? Is there a government stopgap to offer some protections for employers?
All right, so love the question. The NLRB is the end-all, be-all of everything union-related. So the problem is, even if you're like, oh, well, I'm not a union, I don't have to worry. No, because the NLRB actually determines whether you are inappropriately interfering with a potential unionization effort. It would impact probably 95% of all employers. The only ones that it wouldn't would be your really, really small employers. But even there, you could have potential issues if you have a plumber, if you're running a grocery store, because there's a grocery baggers and shelf packer union. I mean, there's unions for everything. So the issue is that this could well be a very big issue across the board, because you cannot have any policies, regardless of whether you are a union or not. You can't have policies that are deemed to be anti-union, because then you could be attempting to undermine a legitimate effort to unionize, and that's the big concern.
I had a private question. I think I know the answer to this. I think I know how you'll answer, but does the NLRB language that talks about this is not meant to limit Section 7 rights, et cetera, in the handbook help kind of counteract if those policies do exist? Like, would people be able to kind of plug those in to reduce some of the liability, or should they just remove the policies entirely?
I would not, personally, I'm not recommending people remove them. Right now, what I'm saying is your policies are at risk because you based them even if you didn't realize it. You've based those, or your attorneys based those, or your SHRM training has been based on the fact that, look, the NLRB has said, civility training's okay. It's good to have anti-disruption at work. We have an anti-violence policy. Everything's okay. Now what you're going to have to do is we need to just tweak it to be very careful that it doesn't affect unions. So you're going to want to go in and add language that softens it. Obviously, this policy is not intended to thwart any legitimate discussion between and among employees. They call it water cooler talk. So you can't monitor people's online activities to stop them from complaining about the company. It's the same reason why that logo use, the proprietary information, what they're trying to do is they're trying to allow tattletaling to be legitimized. And this is one way to do that. So that's what that basically is. The incentivized with the $100, the $75 to $25, I will tell you that that has been squarely addressed, that was perfectly fine until they froze the wellness policies at the end of January. I think it was January 29th. So there was a time period where everybody was saying, let's incentivize this, let's go ahead and allow people a gift card, a bonus, a this, a that. The problem is that when they froze all of the wellness plans under the EEOC, HIPAA, ADA, and so on, this is all brand new. Typically, we would find this out, 6 months to a year down the road. I was really disappointed when the executive order came out and froze the wellness and shut down all these things, because we were in a confusing time period where, let me just pick the Kroger because it's been put in the chat. Kroger's already incentivized this for some of their employees. So now let me ask you, if I tell you to treat everybody the same with the golden rule, how does Kroger pull back on that and say, well, now wait a minute, the new administration has said that might be considered a mandate because we're giving you too much money, but we've already given money to 33% of our workforce to get vaccinated. Now, how do they undo it? So my concern is, and it was on the day that all this happened on January 21st, where we had, 28 different executive orders published canceling and voiding everything. The issue was this: non-political. You voided everything, you create a vacuum, and you didn't fill it with guidance. That creates uncertainty. And what's the one thing we don't want in the business world as an HR professional, as a legal writing policies? We need certainty. We need to know what the government's going to do if we follow these things. And instead, what we had was, like the NLRB, you're perfectly fine, put it in your handbook, everything's great and wonderful, these 9 things are good, and then all of a sudden it's, we void that memo. We haven't replaced it. We'll let you know in the next 30 to 90 days, we'll replace it, but right now that memo is hereby void. That's scary, because that changes everything, and we don't have answers for what did that change.
Okay, and then I think we've got one more here. If an employer doesn't make it mandatory nor encourages the vaccine, can they request documentation that an employee took the vaccine if they're asking for approved time off for side effects?
Start over and ask that again. That had 2 parts. I missed the first.
Yes, so if an employer doesn't make it mandatory or encourage someone to get the vaccine, can they request documentation that an employee took the vaccine if they're asking for approved time off due to side effects?
Wow, that one is a really, really interesting one. So no, the employer had no impact on the employee getting it, but now the employee has symptoms related to it. You cannot require proof of a vaccine. I don't think you should require proof of the actual vaccine. You may get it, but don't ask for it because you didn't require it or encourage it. but you can require documentation of the symptomology in some way, shape, or form. So you've been told by the CDC, by the state, by the feds, if a person has symptoms and needs time off, you're supposed to let them have time off. You're supposed to be lenient. You're supposed to not require a doctor's note. If they hand you the vaccine and say, here's the vaccine and it caused the following, and you can look at the CDC and see that the vaccines are in fact causing a milder, sometimes, impact where people do have that issue and they do need to quarantine, then you can basically say to them, okay, Sally, you said that you have this side effect. Can you document to us at all how that came up? And then they can answer that question for you, and they'll probably do it by showing you the vaccination. But I would not personally say, send me your vaccination if you didn't encourage it at all. What you need to say as a non-medical professional is send verification of your illness in some way, shape, or form. And then again, don't require the doctor's note because they told you to lift it. Christina, the response is yes, phase one opened, phase one Charlie opened today. Oh, somebody answered it. You still are prioritized on the other. So that's it.
All right. So I spoke too soon. We've had a couple more come in while you were talking there. Any word if the voluntary emergency leave will be extended past March?
Nope, none yet. Might be in the, you guys have noticed too, I told Lyle this morning, the House passed $1.9 trillion. A lot of that money has nothing to do with COVID. There's certain parts of the educational side that it looks like between 5 and 10% is what's on the
All right, can you hear me? All right. So my phone was ringing. I went to ignore it and somebody answered it. So instead I hung up on my phone call with you guys. Sorry. So I didn't include anything on the $1.9 trillion for two reasons. One, a lot of it is not COVID related. It has a lot of other expenses in it. More importantly, Senator Manchin in West Virginia is the single most important right now. Because he is literally the one that, if he says yes, it will be law. If he says no, it won't be. And until we know how he's going to vote on this, I didn't want to talk about it a whole lot because it's really completely up in the air. So we didn't include all of that. So I don't know what the status of some of these things are. Stand by. It's going to be an interesting, in the next 2 weeks, I thought it was going to be before today, but the next 2 weeks, there's going to be a whole lot going on.
Okay, okay. And in regards,
Yeah, one of the questions, I had a private one to me that I wanted to share. I'm not going to say from who. In terms of incentivizing employees, what do we do about if somebody, should we allow them to stay on the clock to get the vaccine? Is this considered an incentive? And if so, would we apply that to all employees, whether they get vaccinated or not? That's the issue, is any incentivized program, you need to make sure you walk through the incentives to make sure they don't violate the HIPAA, ADA, and so on. So in the sense of allowing people to be on the clock, you've got two issues allowing people to be on the clock. Welcome to my legal brain here, and I'm sorry to be the Debbie Downer in the room, but if you allow people to be on the clock and they drive to the facility to get their test and they get into an accident while they're on the way to the facility, workers' comp, are they on the job? Are you liable? What if they get killed? And I don't mean getting the vaccine, I mean on the way to and from. Now they're working on the clock because you said, go while you're on the clock and go get vaccinated. The other issue on that side is those that don't go, what are you giving them instead? You say, well, incentivize it for the people that go. Do we give the same incentive to those that don't? Where are they going? So then if they're allowed to go get 2 hours free in the afternoon, then you're going to get a complaint from the people that you allowed to go get vaccinated. Well, but I want my 2 hours in the afternoon. I'm not being treated the same. I had to use my 2 hours to get a vaccine. They got to use their 2 hours to go to the park and play basketball. It's a big issue. You can't incentivize without incentivizing, but if you start doing some that are across the board, then you're cheating the people who actually use the incentive for the vaccine purposes.
Great. Okay, we had a question. We had a question about putting. We had a question about putting in the employee manual about people being civil except related to union activity. I think you kind of already addressed that when you're talking about the language, the NLRB language. If the $15 minimum wage does pass, how long will employers have to put this into effect?
It depends on which version gets adopted. There was talk about it being implemented over a 5-year period. There was talk about changing that to immediate. The left wing of the Democratic Party wants it immediate. The more central centrist wants to trickle it in over time. Not sure what the answer is because we don't know which version is going to be adopted.
That appears to be all of them.
I had a private question I'm going to ask or answer. It was about cancel culture. What happens if you go after one employee but you don't go after all of the employees for the same or similar behavior? My answer to that is number one, the golden rule, except for number two, as long as it's not racial discrimination, sexual harassment, sexual orientation against that employee, you can cherry pick which ones you want to fire. Not smart, but you could do it. But there's going to be a lot of issues with regard to going back. The sample I received was an employee who was angry at another employee, and you all don't have those, I know. But an employee who's angry with another employee, rivalry at work, sends out or complains to the employer about a gender inappropriate comment that was 20 years old. And can we fire the person? And the answer was yes, you can fire the person because it's been brought to your attention and you have a choice. You could or you don't have to. Then the issue is, do you do that across the board? If I was an employer, I don't think I would want to dig in. I dig into people before I hire them, okay? I research the heck out of people like you wouldn't believe behind the scenes. It's why I don't use Facebook, because I use it in my legal. When I'm doing somebody's deposition, I start pulling out when they got married, when their birthdays are, who they're married to. I tell them their whole life story and they're sitting here scared to death because they've never met me before. I don't want somebody doing that to me, but do it before they're hired. Once they're hired, if you start digging too deeply but you're not doing it across the board, do you really want the public upheaval in your workforce because you did this for Sally, but you didn't look back on Jim and you never looked at John and look at what he did, and then you're going to have people tattletaling left and right. Be careful with how you do it. I just want to point out to you the cancel culture's here, so just be aware. And that's not a political comment. That's just literally, there's a lot going on right now with the potential cancellation of things, and you just need to be aware that as an employer, be careful about your own posts. Govern what's posted on your page if it's open forum. Delete things that are potentially inappropriate, and if they're your employees putting them up there, address it carefully with the NLRB out there. That's it. A lot to cover, guys. I'm sorry it took a little longer than I thought.
Wow, thank you, Jim and Allison, for all your questions. Everybody that pitched in things, great. We appreciate it. The floor is open. I like to open it up at the end. Not many people speak up, but some do. Angie Bailey, are you still on there? Open up your camera for a minute. Angie Bailey has joined our HANA resource team in the past couple of weeks, and we are delighted to have her. Many of you, if you live in the Louisville area or Danville area, you probably know her. And we're glad to have her join us. Anybody have any comments or questions? Anybody want to just say hello? I didn't give Angie any warning about this, so I'm sure if she'd do it or not. All right.
Well, there's a lot to cover, and I think there's going to be in the near future. I knew that the NLRB would raise some eyebrows, but it probably should.
Yeah. All right. We've got quite a few chats down here. You want a minute to check those out before we sign off? Thank you all for your nice comments and compliments. And Jim Morris does a pretty good job. We're pleased. And Allison and Autumn, thank you for your input.
A lot of good input.
Yeah.
And I actually have missed it. I didn't, you know, it was nice to have a week where I didn't have to worry about it, but it's fun addressing, not fun. It's important addressing all these things.
Yeah.
Keeping up to date with it.
I think you made people nervous with all those changes, all the changes to the executive orders. And I kind of feel like they ought to keep their powder dry for a few weeks and see what happens. Chances they're going to get tapped in a short period of time, I think, is slim, but you just never know.
Yeah, no, that's why I told them, you know, you need to be addressing it, but you need to wait to see what the next guidance is. But then you also need to be careful. I wouldn't be doing any new policy right now. I'd wait till you get more guidance on the new policy.
Yeah, where you change things. All right, Keith Knapp, thank you for signing on. I think you just dropped off just like that as I said his name. Some of you know.
I'm here.
Oh, okay. Oh, there you go. Keith, thanks for your comments about the vaccine. I guess you're still working on that. And what are we going to do with all the Johnson & Johnson vaccines?
Funny you should ask. There's discussion right now prioritizing the first 2 shipments anyway into the long-term care institutional pharmacy network, because there's not an existing method by which the staff and residents who've been vaccinated in long-term care facilities can get a second dose if they've only had the first dose at the 3rd clinic, 3 of 3, or they're newly hired or newly admitted.
Wow, okay.
So that network is going to be put into play right out of the gate, because that's an easier handle to transport and administer, and it's a 1 dose versus 2 doses. And so to the efficacy rate, I thought that was handled well. My comment wasn't to correct, it was just to clarify that that was a worldwide study, and the part that is most pertinent to North America is a little bit higher. And I thought you did a great job of mentioning the fact that it's 100% against hospitalization and death. So that's way, way better than the flu vaccine.
And if I'd have known that you were on, I would have shut up and let you handle it.
You did great.
People are saying I'm not going to get the Johnson & Johnson because it's only 60-something%. It's like, wait, first of all, you only have to take it once. Second of all, it's not about getting it. It's about it killing you is what they're worried about.
That's right. And that's an important distinction.
Yeah.
So, you know, going bare and waiting for the Pfizer or Moderna to pick up a 15 or 16% efficacy rate against mild disease versus being protected against death or hospitalization, that's a choice.
Go for it.
Secondly, kind of an issue that just sort of creeping in the side door here just this morning, expression by the Archdiocese Roman Catholic Church office about the fact that the method by which the Johnson & Johnson product was developed is decidedly different than the other 2 vaccines, and it relies on stem cells that could arguably have come from aborted feti. Is feti the plural for fetus? I don't know. Anyway, so there could be concern communicated through the Catholic community about Johnson & Johnson for a reason that is actually very difficult to either prove or disprove. And so if there's somebody who's really concerned about that from a religious standpoint, that could surface in a way that would, you know, put it under the realm of religious objection.
I had not heard that theirs was potentially, I knew the other 2 were not egg-based and were not developed through stem cell. I had not
Right.
heard that Johnson & Johnson could have been.
Yeah, and it could have been. You know, it depends on the strain that was used, but it's just as difficult to disprove it. So in the realm of doubt, they were just expressing concern, not opposition, and that is definitely hot off the press, or not even in the press just yet. The other thing
That really could, and I'm glad people are still on here to hear that. And that could really impact our discussion about people who have a inability to take the vaccine. You know, we talked about the allergies under HIPAA. This one isn't allergy, but this one could well create some additional interwoven issues between religion and vaccination if they're being
Absolutely.
forced to take Johnson & Johnson.
Yeah, and even from an ethical standpoint, regardless of the legality, if that's all that's available, and you're are you given second class status because you have that belief system, and you're getting the arguably less effective, and now in opposition to my religious beliefs, it like all things COVID, it ain't simple. But
No.
I am encouraged about the deployment of the long-term care institutional pharmacies, which our state has several, because they're really, they know that business model. They're going to be able to work with the nursing staff that are licensed at the facilities to administer the vaccine. It'll just be a better reach, and probably result in a lot less risk of waste. Somebody asked in the chat about 1C opening today. Absolutely, but with the caveat, kind of a little footnote, if 3 people show up and 2 of them are 1A and 1B and the third one's 1C and there's only 2 vaccines left, the 1A and 1B are still going to get prioritized. So yes, 1C is a possibility, and we're getting a ton more vaccines in the next 2 weeks. So I think it's going to work out just great. But that scenario that I gave, you know, at the end of the day, when they run out, 1A and 1B still are the trump cards. Does that make sense?
Yep, sure does.
Great information.
I thought you did a splendid job. Great job.
Oh, thank you. Honestly, if I had looked through and seen you on here, I would have invited you to be the one to speak about all joking aside, to speak about the vaccine issue with where it stands and the issues with regard to distribution and so on. But
well, yeah, we still have the challenge that what we're told is coming isn't what doesn't match the
what really arrives.
Yeah, what really comes off the truck, and so that's why there's a lot of scrambling. But you know, with the addition of the Walgreens retail outlets and several others that are becoming players, you know, there's going to be upwards of several hundred locations. The only limiting factor being that the distribution of the actual allocation on the vaccines when they get here. So that's a very serious limitation, of course, but there shouldn't be, by the end or middle of March, any Kentuckian who wants to get signed up for and there's enough vaccine for having to go much further than a 20-minute drive in any direction to be able to get it. The bigger logistics concern remains those that are homebound, not living in a congregate care or group setting, because they're onesies, one-offs. But the J&J is a big game changer for that too, because we're going to be working with the home health agencies and others that reach them anyway. Maybe even having EMTs ride shotgun with Meals on Wheels. I mean, we're pulling out all the stops. That's it.
All right.
From the booth.
Okay, thank you so much. Yeah, next time I'll look faster down the list. You know, you got 120 some people to go through, and I didn't notice your name for a little bit. All right. Anybody else want to add anything? Thank you all so much for hanging on.